Good morning. This is the New York City Board of Standards and Appeals Public Review Session for July 14, 2020, the 10 a.m. session. No public testimony will be accepted during this review session. Please do not call in. The first item on the agenda is 2017-99A, 3798 Railroad Avenue, Queens. Do we want to make the announcement yet? Or
Yeah.
Okay. Just for information's sake, the public hearing, which will follow after the review session, we are going to change up the calendar a bit. The third case, which is 2020 11A 301 Park Avenue, Manhattan, which is an interpretive appeal, we will hear that case first when the public hearing starts. The review session will follow the normal course, but the public hearing, we will do the appeals case, interpretive appeals case first.
Okay. Great. So we're talking about Railroad Avenue right now. So this is just the review session for it. At the previous hearing, we asked for a title company review of the documents and easement materials and a statement by the title company's counsel that the subject site is a beneficiary of the easement. Oddly, this title company refused to do it. I've worked with title companies for years and years, and counsel for the title company is charged with learning or deciding what the documents mean. So I found that quite a strange response. But in any event, since the complexity of all of those documents is not for the BSA to analyze and figure out who is a beneficiary of easement. So what I would like to do is have, when we're ready for decision on this, I'd like to have our own counsel note in the resolution that the board takes no position on whether the applicant has the right of access over the Review Avenue easement right-of-way. And in order to render its decision, the board is relying entirely on statements by the applicant that such right exists. So that way it keeps us out of it. And if DOB needs further assurances, they can pursue that. They're still waiting to clarify the tax lot number issues. I do have to say, I'm not really sure what the significance of the tax lot number issue is on our ability to make a decision, whether or not we can say current tax lot numbers A and B, or whether we have to wait until the tax lots are subdivided as intended. So our counsel should look into it, but applicants should address this question. The biggest issue was that the fire department was very uncomfortable with how the building was being used, and would like them to take a look at the latest submission. The owner has committed, Tony, just a second. Okay. The owner has committed to not allowing personnel to park vehicles inside the structure. I'd like to know whether fire department is comfortable with that as a condition to approval, just a standard PSA condition, versus us having that in a restrictive declaration. So, that's the belt and suspenders. Would fire department feel more comfortable if this is something that's recorded against the property? And then they did include maneuverability diagrams for truck versus personnel access in the main, and those need to be included in the main set. So this is, again, a sort of direction to our counsel, make sure that those maneuverability diagrams get included in the main set. Yeah, those were my comments. Yeah, Tony, go ahead.
Okay, so John, the fire department emailed me. Apparently March 26th, after the last hearing, they had submitted a statement regarding that the battalion 45 had gone out. And so apparently it's, I don't know if it wasn't uploaded into the SharePoint folder, I guess. Mm-hmm. But so his current comment is: a review of the case files does not have this email of the fire department's comment regarding access for emergency personnel. Please admit this email to the record that the fire department has no objection to this application regarding fire department access. So the email was March 26th, and the battalions went out. According to, they did a access roadway, they did a turnaround on the access roadway. So they said the access roadway, according to Battalion 45, provides plenty of room for fire apparatus access. According to the Battalion 45 report, there are no hydrants on the premises in question, but 3 hydrants are available in the immediate vicinity. 1 hydrant located outside the main entrance and 2 hydrants located in the open accessible area on waste management property immediately adjacent to these premises. All these hydrants were tested and are fully operational. Room for fire apparatus access to the building was found to be sufficient on the north elevation, exposure 1, on the west elevation, exposure 4, the east elevation, exposure 2 has no room, and the south elevation has construction materials stored. Based on the above noted information, the fire department has sufficient access to the premises.
Okay, that's good. So that's a different question, though. That was the first question we presented, and after one of their inspections, they observed that there were private cars and vehicles being parked inside of that structure. So that my question is, are they okay with us making no parking of vehicles inside that structure just simply a condition to our approval? Or do they also want to see in a restrictive declaration so we have the belt and suspenders? Okay, all right. So then I go to Vice Chair Chanda.
Thank you, Madam Chair. Based on the recent submission, my only question was if FDNY was satisfied with all the improvements that the applicant is proposing to make. And I agree with you, should there be a belt and suspenders of having a restrictive deck that restricts vehicles, that would prohibit vehicles from parking inside the buildings. I would be okay with that. But if FDNY is also okay with it, that makes it perfect.
Okay, thank you. Commissioner Otley Brown?
I have no additional comment. I support your request for a restrictive deck, restricting the vehicles and all sorts of trailers that they had in the building. So I would be fine for voting.
Okay, great, thanks. And Commissioner Shetta?
Thank you, Chair. I agree that we need to specify some sort of restriction on the parking inside the building. I leave it, like you said, for the fire department to pick one of these. Other than that, I saw that the drawings submitted, they do have some like kind of structural details. I just want to mention that we didn't look at them from the structural perspective. It's just from layout perspective, architectural perspective. And we haven't reviewed any of these details. So it's out of our scope and we didn't look at them.
Okay, thank you, appreciate that. And Commissioner Shabeta?
Thank you, Chair. I believe a restrictive deck is appropriate here, and I have no additional comments on this.
Okay, great, thank you. Okay,
Okay, next item is 2019-19A 107 Monet Avenue, Staten Island. Once again, this is a review session, no calls.
okay. I thought the submission was very thorough and addressed the Brock Properties hardship issue very well. The restrictive declaration was amended to provide a cross easement between lots 260 and 262, which is what we had asked for. So I'm okay with this now. Vice Chair Chanda?
I have no additional comment on this.
Commissioner Otley Brown?
No additional comments.
Okay. Commissioner Sheta?
I agree the submission was responsive to our previous comments and I have no additional comments on it.
Okay. And Commissioner Shabeta?
Thank you, Chair. I don't believe that the Broad Properties issues was addressed appropriately, but due to the size of this application and what the ask is and the amount of units that it's asked for, I think it's small enough that it shouldn't be a problem for us. With regard to, I wonder if you want me to expound on the Broad Properties, why I don't believe it's addressed, I can do that. I just don't think it's necessary on this case.
Okay.
Further, I was looking for whether or not the community board received the full packet. I had notes saying that from the original day there was denial, and the complaint was that they didn't receive the full application from the applicant. Now, I don't know if, I remember we did speak about it during the hearing, but I don't know if, I didn't see anything that stated an update on that issue in the paper.
Right. I don't see anything further on that. Yeah, go ahead.
While again, I think this is a minor application. I think it is important to, if this community board stating that they haven't received the full application, I think that they should have the opportunity to review it before we vote.
Mhm. Okay. So maybe the applicant can fill in, because we actually have, it's more than an administrative notice. There's a local law that was passed that says that the community board must receive the same filing as what the board receives. And actually, our administrative notice requires that a copy of those materials be submitted to the board so that we can see that the community board got the same thing as what we got. So that's something that's both a local law. It's in the admin, I believe it's the admin code. Correct me if I'm wrong, Kurt or Jace. And then our own administrative notice requires that a copy of the filing be included in the submissions. Okay, so the applicant should address that. Thanks. Okay.
Okay, so the next item is a new case, 2020-11A, 301 Park Avenue, Manhattan. This is an interpretive appeal. This is a review session. Please no calling in.
Right. So excuse me, but my comments are long because the submission was very lengthy. We have proof of service of initial filing the necessary parties. And the questions that were presented to us in this appeal have had a long back and forth history between the appellant and DOB. Reading the many ZRD1s that were issued in association with it make for very complex, intricate reading. So my comments will most likely reflect the order in which I learned of the building's history and the relevant ordinances. Trying to put them together, put them in some kind of order was kind of impossible because of how I was reading about this. It seems as if at one point DOB was persuaded that accessory parking could continue based on the 1933 appeal, but DOB's 2018 conditional approval of the ZRD1 requiring compliance with the terms of that 1933 approval, in spite of nearly 100 years of changes in the building and fire codes that render the 1933 conditions irrelevant, seemed to direct the property owner into an existential impossibility. The original 1933 variance was to vary fire department fire safety concerns. It does not appear that there was any variation of the 1916 zoning regulations or of any specific ordinance. The conditions of approval were elaborate and appear to relate to fire safety, limiting parking duration to 4 hours and spaces to 21. The resolution provides no citation to any building or fire code section that is sought to be waived. However, there is reference to the code of ordinances in the cited violation. It says, discontinue, this is from the resolution, discontinue the storage, housing, or keeping of motor vehicles on the premises in violation of the code of ordinances, without saying what section. Article 9, section 370, so I'm not even aware of what the code of ordinances is, so I have to try to figure out what they might have been referring to. Article 9, section 370, which is titled garages, in the 1924 version of the New York City Code of Ordinances, which you can find actually surprisingly on Harvard's interactive library, prohibited the fire commissioner from issuing permits for what were called garages, allowing for the storage of what they described as volatile inflammable oil in buildings occupied as hotels. The 1965 submission by the then applicant refers to, that's the 1965 submission for the special permit to allow transient use, refers to Fire Prevention Bureau Code number 308-NSG, and states that use of the driveway for short-term parking is permitted under this code. The 1965 special permit was to allow the transient use of existing parking spaces under section 36-461, which is referred to in the 1965 BSA grant, prohibited rental of parking spaces to non-residents unless a BSA special permit pursuant to section 73-47 was obtained. Multiple dwelling law section 60, paragraph 1 has a similar limitation on the rental of parking spaces. So it seems clear that both DOB and the BSA believed at that time that the building had the right to accessory parking spaces in 1965, even though there was no mention of such parking on the C of O before that time. There has clearly been mention of the parking spaces since then in every certificate of occupancy until the last in 2010, even if the mention as to transient use refers to an expired BSA special permit. So it's constantly reference to parking, whether or not it's allowed to be transient. The loss of the right to use the spaces transiently didn't evaporate the accessory spaces that were the subject of the 1965 special permit in the first place. The 2007 BSA surrender letter confirms that they surrendered the special permit that had expired in 1980. The 2007 BSA surrender letter confirms this by stating that after the lapse of the 73-47 special permit and MDL waiver for transient parking, the spaces were used for what they say, valet parking and drop-offs. So I don't even need to, as is pursued by the appellant, I don't even really need to go to Victory Van Lines in this case, but I'm very surprised to read that although DOB has in past cases before this board, notably in 2006, BSA case 5-05BZ for 59-25 Fresh Meadow Lane, the DOB expressed agreement with Victory Van Lines. Now it distances itself from that holding, asserting that modified language in the 1968 building code that was not present at the time the court rendered the Victory Van Lines decision somehow or other should have alerted this hotel owner to the need to amend its certificate of occupancy in 1980. So I'm not understanding how the Department of Buildings relied on Victory Van Lines until this case, it seems. And I don't believe one has to rely on the terms of the 1933 variance, since that variance was, as I said earlier, related to fire safety concerns about placing the parking in the driveway and was not a use waiver. The buildings commissioner at the time stated as much in the text of the resolution by stating it is the opinion of this bureau that the use of the premises as outlined in a letter referred to is within the scope of the certificate of occupancy issued upon the premises and does not violate the provisions of the code of ordinances. So it's two different things. So there's a zoning resolution that is regulating use, and there's also this kind of version of the building code prior to 1938, code of ordinances. So I see nothing in the 1933 resolution indicating, as appellant states, that parking anywhere in the building would have been prohibited, or that the 1933 BSA grant waived 1916 zoning regulations. Appellant did not provide us with a 1933 zoning or code of ordinance analysis with respect to parking restrictions, although the 1916 zoning resolution did not appear to restrict the number of vehicles that could be parked in a private garage as an accessory use. And I say this because the 1916 zoning resolution for residence districts says the following, but you don't see that same sentence as to business districts. It says, a private garage for more than 5 motor vehicles shall not be deemed as an accessory use. That's what it says with respect to the residence districts. But if it was prohibiting more than 5 vehicles in a building for business districts, you would have thought that they would have appended that also, that little paragraph at the end. So, and it has the comment The term accessory use shall not include a business, nor shall it include any building or use not located on the same lot with the building or use to which it is accessory. A private garage for more than 5 motor vehicles shall not be deemed an accessory use. This was in the residence district. So appellant's materials attached to the ZRD1, or there's many ZRD1s, ZRD1 request, states that the amended 1916 zoning resolution liberalized to allow more parking spaces in business districts. If, as appellant contends, and as a City Planning Commission report confirms, the 1940 zoning resolution allowed more parking as of right at the hotel, wouldn't it have then rendered the 1933 variance moot with respect at least to the zoning resolution, but perhaps not to fire code, fire safety concerns? And then I asked, did the 1938 building code supersede the code of ordinances, therefore rendering that moot? We often see these kind of variances where a change in the zoning and sometimes a change in the multiple dwelling law, like we have with the GCL 36s, for instance. There was a change in GCL 36 that wouldn't, they often render the variances moot, and rather than surrender the variances, it just kind of evaporates the variances by operation of law because it's now complying with the new conditions. So if the 1940 zoning resolution, and I'm going to just read a little section that the appellant provided us with, it was 1940 zoning resolution amendment, where section 4A15, it says the inability of the designers and operators of business buildings to make any provision for the parking of the cars of tenants and customers has contributed largely not only to the congestion in central business districts, but in some instances to the difficulty of doing business in all such areas. The amendments to this paragraph make it possible to provide such facilities again under safeguards that are believed to be adequate. Its adoption is an important step in any program for adapting to the city to the needs of the motor age. So it sounds like more cars were permitted as of right by 1940 under the zoning resolution. The amendment, let's see. Okay. So the BSA's letter of no objection, which was issued in whatever it was in 2007, I believe, in response to the applicant's request for PCE. The BSA's letter of no objection was very specific about its limited scope. So I have a problem with DOB expanding what a letter of no objection is from the BSA. It was not, after all, a letter of substantial compliance, which is a completely different kind of review of the application. It's simply the board stating that it has no objection to the use continuing, but it's not the same as determining whether the proposed use is in substantial compliance with the terms of the prior grant, right? And so it merely states that the agency has no objection to the continued operation of the accessory parking spaces, and DOB should not be reading into the meaning of this L&O. Another way of looking at this question in general is that the 1961 zoning resolution rendered the 1933 variance unnecessary, and I add to that maybe the 1940 zoning resolution did that, rendering conforming the pre-61 use, and the 1965 special permit merely acknowledged that legalization. I think the cover letter, however, that accompanied the 1965 transient parking variance request, which is DOB's uses, confuses the issues because it implies that there was no existing parking in the driveway absent the transient parking approval, but the resolution isn't allowing new accessory parking space. It is merely allowing existing accessory spaces to be used transiently, or rather, they don't even need to be existing. Parking spaces that are allowed to be used transiently. So if in 1965, the zoning resolution in the Manhattan core allowed for accessory parking, this was simply saying, okay, you can use your accessory parking transiently. And as with all of the transient recapture provisions in the zoning resolution, they acknowledge that accessory parking spaces, whether required or permitted, are often not used as intended, and that a transient use is a way of rectifying that condition. So we have in the zoning resolution the opportunity for residential parking spaces that are not used to be used transiently, as long as, or used not necessarily transiently but not as an accessory use. So essentially treating them like a public parking garage until there's a recapture by a tenant. DOB focuses on 1980 as the establishment of the use date. But first of all, I don't understand why they insist the use would have been established then, when it was established first in 1933 and again in 1965 and appeared on all subsequent certificates of occupancies, and photos show no discontinuance of that use. The 1980 version of the building code did not require new certificates of occupancy for existing uses in existing buildings. And second of all, this is an accessory use permitted as of right since at least 1940 by the zoning resolution. And so like in Victory Van Lines, where the truck storage was accessory to the principal use, parking associated with a hotel use was permitted. The limited duration of the parking under the 1933 variance was related to fire code, not the zoning resolution. The 1965 special permit specifically allowed as of right long-term accessory parking to be used transiently. So I'm a bit surprised to hear DOB take the position that the lapsing of a permit to allow parking to be used transiently evaporates the parking that was previously used as permanent accessory parking. According to that logic, the permitted transient use of required accessory parking in residential buildings, or not transient, but let's say public parking use in residential buildings, and the recapture provision that's in section 25-412 of the zoning resolution would require the certificate of occupancy modifications every time a tenant gave notice of an intent to recapture a transient space. I find that really surprising. And that's what was implied, I think, in their most recent submission. More than implied, I think it was stated. So I have to say that I get the impression that DOB is interpreting section 13-07, which is existing buildings and off-street parking facilities in the Manhattan core, essentially the way it does for the relocation of signs under section 52-82, which basically doesn't allow for any relocation of spaces. But I don't see any prohibition on the relocation of spaces in section 1307. Proof of that is 1307 paragraph 1 that prohibits the reduction or elimination of existing required accessory parking absent a city planning authorization. Where a zoning lot is modified by, say, an enlargement or reconfiguration, removal of the required number of spaces to accommodate the enlargement would not be permitted, but relocation of the required spaces to, say, the cellar of the building most certainly would, because you're not permitted to reduce the number of spaces that were required prior to the creation of the Manhattan core parking regulations. I'm really not getting what DOB is concerned about with this case, like what floodgates it fears will be opened by allowing this use, and I'd like them to address that. We're talking about something like 25 parking spaces. What's the fear here? And are we being asked to opine on whether the use that is currently accessory to a hotel would now be accessory to use group 2, which seems to be implied in DOB's last submission? The building has always been occupied partly transiently and partly permanently. This is a 1929 apartment hotel building. None of the certificates of occupancies, none of them, designate a use group to the building since it was constructed as a 1929 transient hotel and residential apartment building. I guess the main thrust of this is I'm not sure what DOB is concerned about and why they keep, every time appellant responds to their concerns, they they're not satisfied with it, or they're satisfied with that, and then they seem to be finding something else that would shoot down the last argument. So apologies for the length of that. Vice Chair Shanda?
Thank you, Madam Chair. For the very thorough analysis. My comments are very similar, so I'll probably reduce some of my notes. In the documents DOB has submitted, DOB states that hotel use of accessory off-street parking space could only have been established as of right from 1961 to 1965, which is prior to the BSA variance, or from 1980 to 1982.
So Shampa, we're having, oh, is that my internet or her internet? I'm gonna switch, sorry.
Okay. I'll start all over again.
Yeah,
Can you all hear me?
please. Yes.
Okay.
Is it breaking up for others, or is it just me? Because I'm not sure whose internet is unstable. Tony?
No.
Not yet.
What? No, I'm trying to understand. Is it her internet or is it me?
Mine
I
seems
believe it's
fine.
yours, Chair.
I think it's
Might
you.
be just you.
Okay, I'm gonna be switching to another Wi-Fi, so continue.
Should
and
I
I'll-
wait or should I continue? Hello?
Yeah, now I'm
Okay.
back.
So in DOB's letter, DOB states that hotels' use of accessory off-street parking space could only have been established as of right from 1961 to 1985, which is prior to the BSA variance, or from 1980 to 1982. DOB further states that hotel parking between 1965 and 1980 operated under the 1965 variance for transient parking, not accessory parking. And this is where I do not agree with it, and goes to the argument of why I don't think that the 65 established it as only transient parking. The 1965 variance allowed the use of the existing parking spaces to be rented to transient who are not associated with the principal use of the building. The 65 variance was granted under MDL 60, and which allowed for parking spaces accessory to MDL to be rented to transient when not used, and that the space be made available to an occupant within 30 days after written request thereof. So if an occupant of a multiple dwelling requests for one of the accessory spaces to be made available, then within 30 days it is turned over. So exercising MDL 60 does not make the accessory use of the parking space extinct. It just is an MDL 60 allow the transient use is just an interim use. It is applied to accessory parking spaces. And so therefore the applicant's justification for renting an accessory space for transient use in 65 did not contradict the establishment of the accessory parking. What I'm getting at is basically you had to have an accessory parking spaces, and if only you had the accessory parking spaces, then only you can use that towards transient use. So that in my mind establishes that there was an accessory parking space on this site. It is like saying that all of those accessory parking spaces in the residential building that are being used by transient per MDL 60 or even zoning resolutions 1321, which is public use of off-site parking spaces, has stopped being accessory parking spaces once you start using it for transient purposes. And as Madam Chair mentioned, does that mean every time a switch is happening between an accessory and transient, a CO has to change from an accessory to transient? I think it's just an additional layer on top of the accessory parking. Accessory parking doesn't go away. And at some point in the DOB document, it stated that the applicant had stated as part of the 1965 that the parking spaces were underutilized and they were not being fully used by, and therefore by the hotel users, and therefore they were requesting the transient. That was more to meet the findings of that special permit. I do not think it had to do with that. It almost seems like saying if a residential building has an accessory parking spaces and those accessory parking spaces are not being used, that means that use evaporates because it's not being used. That's not how, it's not the sign. Like if a sign structure does not have a sign for a period of 2 years or something, then it stops being you cannot, you're not legally lawfully confirming sign. But that's not the same principle that is used when it comes to accessory parking. Accessory parking is there whether someone uses it entirely, partially, or not at all. So I'm just confused by the way the argument has been presented by DOB. And as I read the documents, I definitely do not see that the accessory parking spaces evaporated after the 1965. It was always there from the beginning. And the 1933, as Madam Chair mentioned, is the 1933 appeals case was based on allowing, it was more around the fire safety measures, around allowing the driveway to be used as for accessory parking. It did not establish accessory parking. It just assumed, it accepted the fact that accessory parking was there, which was based on the building superintendent's letter, which determined that it did not violate, it was within the scope of the CO and did not violate the provisions of the Code of Ordinance. And BSA's determination of the appeals was just around the fire regulations. So I think even before 1933, it was established that there was an accessory parking, and all of these variances and appeals were around other measures. It did not re-establish accessory parking spaces. So that's how I read it. I though would like the appellant to provide a little bit more of the chronology of the parking regulations, how it applied from 1961, and how and what were the requirements associated with the hotel. And also I was looking for the Code of Ordinance. If it's possible, I would like to review that also.
Okay.
Those are my comments.
Okay, great. Thank you. The Code of Ordinance, by the way, I just found it by searching, doing a Google search, and I can send you the link, but it's in Harvard's library of all things. It's the New York City Code of Ordinance from like 1908. Okay, thank you. Commissioner Otley Brown?
So I didn't find the DOB arguments to be persuasive. It seems like there was accessory parking established at this site, recognized by city government agencies, both DOB and BSA, all along, just from seeing the reference to driveway on the C of O, as well as the zoning resolution 1933 variance for accessory parking, which really was an as-of-right use with a variance of FDNY regulations for fire safety, to the 1965 transient parking variance, which implies that accessory parking is in place in order for you to be able to use those spaces transiently, as well as the surrender of the 1965 variance, which led to both DOB and the BSA recognizing that in this case, then the ZR 1933 C of O with the accessory parking comes back to the fore and then is valid again. So I'm not quite sure why DOB is really digging in its feet on this issue, because ultimately, if you're recognizing that accessory parking was there since the get-go, why are you arguing about them putting it in the cellar or the subcellar, which to me is lessening its effect on the neighborhood to be underground? So I'm not really sure. And if you have issues about fire safety, why can't you just slightly amend those fire safety regulations to be more apropos to 2020? So then I just have a couple of questions for DOB, which is, does DOB require apartment buildings to get a new C of O every time they rent an accessory space transiently, or when the transient space then reverts back to accessory use? And can they give us examples? And then I have another question. Why doesn't the 1984 Article 1, Chapter 3, Section 13-013 previously approved special permits authorization rule on this case that the new provisions don't alter any BSA special permit authorizations, which should, to me, lead one to conclude that if the accessory parking is in place, then the new Manhattan core parking regulations should not disturb that because it was put in place with the BSA signature on it.
Mhm. Can you say again, zoning resolution 13-01, what?
It's the 1984 Article 1, Chapter 3, Section 13-013. It was submitted in the initial application
Okay.
for the 1984 Manhattan core regulations.
Mhm. Oh, okay. Mhm. Go ahead.
So then my other question for DOB is if both BSA and DOB agree that the 1933 appeal gets reactivated since the 1965 variance expired and was given up, why won't DOB allow the relocation of existing spaces? Is it once at the BSA, always at the BSA? Is that what they're trying to say? That we would be the people who have to sign off on it being relocated to the seller and subseller? I'm not quite sure.
Mhm.
That's it.
Okay, thank you so much. Okay, Commissioner Shaitan?
Thank you, Chair. I'll try to be brief. My take on this case is that if you look at the initiation of this case, originally the hotel came to the BSA back in 1933 for permitting the parking use in the driveway. At that time, after like the review of the BSA and the fire department, the fire commissioner, the BSA issued a resolution that, in my opinion, did not tie the use to the driveway. If the applicant initially came for permitting that use in the cellar or the sub-cellar or even in whatever, and the fire department did their review and they concluded that after the review, it is okay, it is safe, I believe that then BSA resolution could have been use this parking, or you could place this parking in the cellar, and then we have no issue. But I believe that the way that the 1933 resolution was written, that the specification of the location was just like a protocol thing. We just specified the location, not to tie that parking use to the location. So I believe this is one of the points that the DOB is confusing here. The second thing, my understanding is after the 1965 variance surrendered or lapsed, that there were like regulations back then that permitted the parking use. And that's why, in my understanding, the hotel didn't care and didn't pursue any further action with either DOB or the BSA. I wanna like make sure that I repeat the point regarding the letter of no impact. It's no objection. It shouldn't be taken as it's just indicating that the BSA is still maintaining the same position similar to what they maintained back in 1933. I feel during reading the documents, I feel that the DOB is mixing ideas. Sometimes I feel like they are looking at the use in the driveway as if it was illegal. But in some other locations, I see that they have no objection for that use to continue in the driveway, not relocated or not located to somewhere else, but hey, applicant, you could continue the parking in the driveway. And in other locations, they denied the request to relocate to the cellar and the sub-cellar because they believe that the use in the driveway is illegal. So it's contradicting, two contradicting ideas. Whether if you consider the use as legal and you want them continue that, or you allow them to continue that, then you cannot base your denial for the relocation based on the claim that this is not illegal use. It doesn't stand. So I need to like get some clarification on this. DOB, are you considering the current parking in the driveway legal or not? And if the answer is yes, it's legal, then we'll move to the next point. Why are you saying we cannot relocate because it's illegal?
Okay, anything else?
It sounds like in their back and forth with the applicant, DUB is just looking at the final ZRD, the final determination. I don't know why. This is one of the cases that I was like, my head was spinning because of how many ZRDs were submitted to the DUB and different responses from DUB on that. So I'm not sure why. What is the reason for like different responses every time? Like you said, Chair, every time the applicant try to resolve an issue, I feel like DUB jumped to another reason not to allow them to relocate. So at the end of the day, I'm not really convinced with the argument by the DOB, and I believe that probably will stay my position for this case to the end.
Thank you very much. Commissioner Shabeta?
Thank you, Chair. I agree with the statements that were made by you, Chair, Vice Chair, Commissioner Holly Brown, and Commissioner Sheta. I found this to be quite a frustrating application. I believe that the applicant did a great job and has continued to try to jump through the hoops that DOB has been setting for it. And as I said earlier, upon every success, it seems like something else would come up. And I don't believe this kitchen sink approach is really the role of the Department of Buildings. I haven't found any of the Department of Buildings arguments to be compelling. That being said, I do want to inquire of Commissioner Holly Brown her statement with regard to whether DOB's position was that this should be before the board as it has a board history. I didn't consider that before, and I'd like to know how the board feels about that.
Mm-hmm. Mm-hmm. Well, I'd like to know how DOB feels about that. Because normally, when we have and Carlo and Commissioner, I'm sorry, Mr. Costanza and Commissioner Ali Brown, and Ms. Matias, who have long institutional memories, jump in at any time on this. But my understanding is that with cases that are related to waivers of some other code, it isn't once at the BSA, always at the BSA. When the fire code is being waived, then they build according to the fire code, and that's that. And so to come back to us and say, can we have more of a waiver from the fire department? They don't need to, because it got built according to that, and you're done, right? So that's my impression when we have looked at other things that have been waived. Plus, in the 1930s, this is so interesting because we have, I think it's actually our Deputy Counsel Vine who put together this long history about the creation of the BSA. And in the 1930s, there were fewer commissioners. I believe it was 3, and more than one of them was a fire chief. So at that time, the role of the BSA was actually fire protection. And so because the zoning resolution wasn't that old, right? So there were variances and there was fire protection, and that was kind of the realm of things. So that's my understanding of when we've waived code provisions like that it doesn't stay here forever. And Carlo, do you want to? Is even Carlo here?
Yeah, I'm here.
Yeah. Is that correct?
That is correct.
Okay.
Well, considering that, I really believe that unless Department of Buildings makes a really impressive showing, that this application should not be very long-lived before this board.
Mm-hmm. Okay, thank you.
Okay.
Mhm.
Any more? Are we done?
Yeah, any other comments from anyone? Okay, so now we can move to the hearing.
All
Thank
right,
you.
this concludes the public review session. We will now commence with the public hearing for July 14, 2020, 10 a.m. session. And as I stated before, we are changing the calendar. So the first case that to be discussed, a public hearing, is 2020 11A 301 Park Avenue, Manhattan. So the parties for that can call in. It'll be Paul Silver from Kramer 11, I think, and Mark Zoltan from
DOB.
DOB, sorry. And I think Felicia might be in the call.
Mhm.
Felicia Miller,
Yeah.
DOB.
Okay, I hope to test, someone tested out our link to make sure that it's working.
I think so, it should be.
Okay,
Oh.
I see Paul Silver. Okay.
Felicia was on.
Coming out our link to make sure that it's working. Hi, Mr. Silver, please turn off your YouTube video.
Oh, yeah, okay.
Thank you. And then state your name and also just let us know, did you have any problem with the link getting on?
I
Not
think
at all.
Felicia did. I think Felicia did.
Okay, all right.
Not at all.
Mr. Zoltan is also just dialing in.
Oh, okay, good. Oh, then I won't text. Okay.
So are we waiting? Mr. Zoltan, when you can hear us, please state your name.
I can hear you, Michael Zoltan from DOB.
Okay, are we waiting for Ms. Miller?
And I don't think so.
Okay, so,
Okay.
Second, I just want to mute the YouTube.
yeah, please.
Okay. You can. They don't need to be sworn in, so they can proceed.
Yeah, go ahead.
Okay, so I'm Paul Silver. I'm a member of the firm of Kramer, Levin, Naftalis, and Frankel, and we are land use counsel to the owner of the Waldorf Astoria. We brought this proceeding to ask the board to reverse a determination by the Department of Buildings made in connection with an application for the renovation, restoration, and partial conversion of the Waldorf Astoria Hotel to residential use. The determination disapproved the relocation of the hotel's pre-existing accessory parking spaces from its ground floor drive-through to its renovated cellar. We'd argued to the DOB, and we argue here, that the relocation is permitted as a matter of right. This is because the accessory parking spaces in the drive-through were existing as of April 29th, 1982, as a matter of right pursuant to former zoning resolution sections 3611 through 3613. As such, they were conforming existing accessory parking spaces, and these spaces, pursuant to former zoning resolution section 13012 and current zoning resolution section 1307, could continue to be used, notwithstanding the adoption of the Manhattan core parking regulations, and for so long as they remained, would continue to be subject to the applicable zoning district regulations in effect prior to April 29th, 1982. Those regulations permitted the relocation of the parking spaces anywhere within the hotel. I ought to say that my analysis was so close to the analysis of the chair and the other members of the board that I'm actually not going to say anything because I wouldn't be adding very much and I'd be taking your time up. I'm happy to respond to questions, particularly Vice Chair Chanda's question about the history after 1980. I just want to be sure I have it right. So I'm going to ask her to ask you, Vice Chair, ask the question again, and anyone else's questions, that anyone else who wishes to ask questions.
Okay, Vice Chair Chanda, go ahead.
I think my question was more about having the chronology of the parking regulations that applied to this site from 1916 onwards, and where the accessory use, like the use really started being applied. And I'm assuming it's from 1916 onwards. Just would like the text to kind of verify that. And I don't think I raised a question on the 1980s. The only question I had was with regards to the transient use, the residential buildings, when they have accessory uses, accessory parking spaces, and those are being used for transient purposes, it doesn't evaporate the underlying accessory use of those parking spaces. 30 days later, if I want that parking space back, it becomes accessory and the transitory use disappears. And that's how the text was written, and it's been applied.
Mhm.
That's always been our understanding. Otherwise, section 60 of the multiple dwelling law, and actually in the residential use sections, actually in all of the sections applying to residential accessory parking, there is that recapture provision. And that will be surplusage if that wasn't correct. I think maybe, I'm not sure that this is going to answer the question. But I believe that prior to 1940, the zoning permitted accessory parking at this location in business districts. And the issue here was the providing more than spaces for more than 5 vehicles under the fire code, as I understand it.
Mhm.
I will have to pull, we can pull the provisions specifically and send them to you in a post-hearing submission, so that the chronology is in effect apple pie order. But the right to accessory parking was there from the beginning. The board authorization allowed the full proposed use because it established conditions to respond to the fire department's concern. And then from 1940 on, basically, because of advances, we think because of advances in construction and better understanding of how vehicles operated within a garage or were stored within garages, the building code and fire code provisions were, advanced to an extent that you didn't have to have special rules for accessory parking at this location. You could operate under the generally applicable provisions of the building code, and that continued in 1940. After 1940.
So I have a question about this, just to clarify it, because there were some sort of cloudy places, right? So we have the 1916 zoning resolution that not so clearly for the business districts permitted accessory parking. It just seems to be permitting it in business districts by the absence of prohibiting it the way it does in the residence district. So, but then also in 1940, the zoning resolution is amended where the City Planning Commission admits that it's time to get into the car age and allow for accessory parking more liberally. So my question is, we have that CPC report that you gave us that says, okay, now parking is allowed more liberally. And I actually don't know how liberally, but so I don't actually know what kind of limitation there was, but the Code of Ordinances up in 1933, it seems, or let's say I only was able to find the Code of Ordinances from like 1924 on the Harvard website, but maybe I didn't go to a legislative library or anything, right? So the Code of Ordinance in 1933 probably said the same. You're not allowed to have parking in a hotel. But if it seems that the 1938 building code would have kind of meshed with the 1940 zoning resolution, so that in 1938, as long as you did the following things, whatever they were, you could have parking as of right in the zoning resolution and in the building code. And that seems to be the missing link. And it seems to me that if we found that the 1938 building code allowed the parking as of right, that you don't need fire department waivers anymore, and that maybe the building itself could have checked the boxes and said, we already have those things, then it would have obviated the need entirely for this 1933 variance of the Code of Ordinances. And so you're no longer before the BSA at all. And it's just that the building never relinquished, or let's say officially relinquished, the variance. You know what I mean?
We'll take a look at it.
Okay.
I'm getting an echo. I don't know whether you guys are hearing it, but I'm hearing an echo. Okay, so yes, we will take a look at the 1938 building code and get back to you on that point as well.
Okay. Any other questions for Mr. Selver? No? Okay. Okay, thank you very much. So,
Thank
Mr.
you.
Zoltan, thank you.
Good morning, Commissioners. Michael Zoltan on behalf of the Department of Buildings. This is an appeal of a department determination that 25 accessory parking spaces cannot be relocated to the cellar and subcellar of the building, since the appellants cannot provide enough evidence to show their lawful non-conforming existence. To understand the request, as the board mentioned, there is a long history here, so I wanted to review the timeline one more time for all of our edification. In 1929, the building was built, and in 1931, it received its first CO, which notes a driveway as a use on the ground floor. As the building was located in a business district at that time, the zoning resolution only permitted storage of 5 motor vehicles. So in 1932, the fire commissioner ordered the building to stop using the driveway for the storage of motor vehicles, as it was contrary to the city ordinances. This order
Well,
was...
Just to clarify, not city ordinances. It seems like it was one ordinance and it was related to fire code as opposed to zoning, right?
Okay.
I mean,
I didn't
until
think it was so
proven
clear, but
otherwise.
sure.
Yeah, well, until proven otherwise, that's the point, is we don't have a zoning analysis, but my own research indicates that it was permitted under the 1916 zoning resolution. And certainly in 1940, it was permitted very clearly because the CPC report talks about parking.
Sure. If I may, and should there be future submissions, I would like to review whether or not more than, irrespective of whether or not the specific 1933 BSA appeal dealt with zoning at all, or if it was just about the city ordinance for fire safety, whether or not it was permitted to store more than 5 motor vehicles on the premises under zoning. In any event, in that 1933 appeal, the superintendent of buildings weighed in and confirmed that the CO authorized cars to remain on part of the space temporarily for the convenience of guests and patrons, but at no time are such cars allowed to be stored or remain permanently in such space. The board then granted the appeal and approved the parking for 21 cars and not more than 4 taxis, subject to those 13 conditions. Crucially, in this case, is a limitation on the location of the temporarily stored cars. It limited it to the driveway as one of the conditions. In the 1950s, there were 3 more COs issued for the building in 51, 53, and 57. Those COs all reference driveway as a use, the same use that was there since 1933. In 1961, the zoning resolution was amended to clearly allow 150 accessory parking spaces for all the permitted uses in the building. In 65, BSA granted a variance for the purpose of permitting the renting to transients for parking of unused space in the existing driveway for up to 28 vehicles for a term of 15 years. A year later, in 1966, a new CO was issued, and it references driveway transient parking as a use on the ground floor. It also contains a descriptive note describing the 1965 variance permitting the transient parking for 15 years. In 1980, by the terms of the variance, the authority to use the driveway for transient parking ends. In April of 1982, the Manhattan Core parking amendments came into effect, and the establishment of new accessory parking was no longer permitted. Existing lawful parking was permitted to remain. Later that year, July of 1982, a new CO was issued. It continued to reference that 1965 variance, and it said driveway transient parking as a use on the ground floor, even though by the terms of the variance, it had expired. In 2000, a new CO was issued. Same as the July 82 one, it continued to reference the 65 variance and driveway transient parking with that note, even though the variance had expired. In 2007, in connection with a PCE application, the building affirmatively surrendered the already expired 1965 transient parking variance. In 2010, the most recent CO was issued, And there is no reference to a driveway use at all. But for a note, the same note on the bottom remains that reference the 1965 variance. So this brings us to today. The department has denied the request to confirm that, pursuant to zoning resolution 1307, permitted accessory parking was lawfully established prior to the 1982 date and can therefore be relocated to the cellar and subcellar and not considered a new use. The department denied this request because the only established accessory parking at the building was the parking granted by the board in 1933. That appeal specifically limited the location to the spaces to the driveway, and therefore the department is prohibited to permit their relocation to the cellar and subcellar.
Can I interrupt you right there?
Sure.
No, the request was to park in the driveway. It didn't limit the location of spaces to the driveway. It said, if you're parking in the driveway, you have to do the following things to make this safe, because in 1933, they were afraid about volatile oil products, petroleum products exploding. So it's not correct that it was limiting it to the driveway. It's not the terms of the grant. It's the terms of the grant are provide the right number of fire wardens or fire extinguishers, don't have people idling in the cars for more than a certain amount of time. They obviously didn't want a lot of cars under the building at any given time, that kind of thing. So yeah, Commissioner Sheta has his hand up, go ahead.
Thank you, Chair. This is one of the points I raised. I believe one of the confusions that the DOB is making is they confusing what I call it specification with limitation. The appeal resolution, the 1933 appeal resolution, did not limit the parking to the driveway. It is specified the parking on the driveway, and there is huge difference. It didn't say that you cannot park anywhere else. If this appeal came to the board to park in the cellar or the subcellar, we could have placed instead of the driveway, the cellar or the subcellar, and specified the conditions that came from the fire department. There is a big difference between specifying something and limiting something.
Right. Okay, proceed, Mr. Sullivan. Thank you.
So to respond to that, I'm reading from the very fuzzy 1933 resolution specifically. Yes, obviously at that time the request was for the parking to remain in the driveway. That's where it was. But there were 13 conditions. The first condition is condition 1, that parking space shall be restricted to the central portion of the driveway shown on the plan submitted with this appeal. There is a difference, obviously, between a description of what the current layout is and then any conditions that the board would have required. In this case, it happens to be that they're one and the same, that one of the conditions is specifically limiting the location to where not just that has to be in the driveway, but in specific portions of the driveway. And yes, that was in accordance with the plans that were presented, but it is a condition of the decision.
So I'm going to recognize Commissioner Ollie Brown, who's probably about to say what I wanted to say, but I'm going to let her say it. Go ahead. Unmute yourself. You're muted, Commissioner.
It seems it directed the cars to the center of the driveway because one of the fire safety concerns was that the cars be too close to the walls. So it wasn't a zoning decision that led them to say, let's place it in the center. It was a fire safety condition. And it seems to me that if the appellant has an appeal of fire department regulations regarding the parking, and the BSA grants the appeal, that the parking itself has to be an as of right use. Otherwise, they would be here for a variance and an appeal. They wouldn't just come for solely the appeal. If you couldn't have the use as of right anyway, what would you be appealing? So that's my question as to the whole establishment of 1933.
Understood. The one thing I will note, and this I can brief more on, is the use that is described in 1933 is this drop off short function visits. One of the described, also a condition, but also a explained use, the way the driveway was going to be used was for short term, not more than 4 hours, for very short events. And this I would like to research and brief on whether or not that was permitted by zoning, but the permanent storage and full accessory use was not permitted. And that's why the letter from the superintendent of buildings in 1933 permitted this. And this was in accordance with the CO that had driveway, because this short 4-hour quick visits use of the driveway was allowed by zoning, but possibly long-term parking, full accessory, was not.
Correct. So I don't want to rehash all the there's hundreds of pages in this submission, right? Every ZRD1 was almost a 100-page document. So I'd sort of like to cut to the various chases and say, first of all, it's a similar question that I asked Mr. Selver. If in 1938, the building, which we know, the building code was amended. If the building code amended said now you can have parking pursuant to the zoning resolution that was amended 2 years later, right? And I'm assuming that all this was going on sort of simultaneously, because that's how codes get revised, right, on a massive scale. Then if the building in its then state met the requirements of the 1938 building code, wouldn't it have been irrelevant what the BSA had allowed in 1933? I mean, in terms of 4 hours of parking and so on, because now the fire commissioners are no longer concerned about that because they've improved construction technique, or maybe the cars don't explode anymore, or whatever it is. People are no longer as afraid of the cars in 1940 as they were in 1933, right? So what I'm trying to understand is, why is Department of Buildings, it's a simple question, why is Department of Buildings insisting on going to 1933 antique fire code requirements and holding on to that, when it knows very well that cars now drive under many, many hotels? We have them all over the city where cars drive under the Marriott Marquis and so on. And we're not really worried about the cars exploding, and there's adequate sprinklers and fire protection and so on. So what is it that the Department of Buildings, I see you, Commissioner Chanda, what is it specifically that the Department of Buildings is concerned about? Why are they digging so deeply? They're digging their heels in so deeply on this case. What is the evil that's trying to be prevented?
I'm not sure if I'm waiting for the vice chair.
Oh,
No, that's my first question, and then we'll ask the vice chair, because it's
Sure.
separate.
Sure. So I don't think there's an evil that the department is trying to prevent. I think there are two parts to that. One is, and it's important to see the entire timeline and the history of this, because uses are established and then they are removed and disappear, and then they can sometimes come. There's a long history, and you have to see whether a use is maintained as well as just established as of right, and or via any sort of BSA appeal or variance in previous years. So we have to continue along the timeline to see what else happened. One, two, and I think this came out a little bit earlier, I think there's a little bit of confusion, possibly on my end, in terms of the 1933 appeals role vis-a-vis zoning. So this is what we discussed in the previous question in terms of whether or not full accessory parking was permitted in 1933 during that appeal, or if the appeal only confirmed the right to use it for this short period of time. Could they have accessory parking for more than 5 cars? So I think that is something that needs to be reviewed further. But in terms of whether or not something became the 1933 appeal was mooted out by subsequent regulations that permitted it, the 1940, for example, or especially in clearly in 1961, zoning permitted it as of right. That's clear. But I think a lot of this has to be seen through the lens of subsequent happenings at the building. So I'm not going to
We
get
don't need to go through the timelines anymore.
I'm
Commissioner
going to stop on the timeline. I wanted
yeah.
to then briefly discuss Victory Van Lines for a second because the chair mentioned a specific case and I wanted to look into that. A 2006 case. Was that, which case was that?
Sorry.
I believe it's
So-
76.
Say again?
I believe it's 1976 or 79.
No, it wasn't that old.
The calendar
Sorry,
number,
it's 2006, sorry, Carlo, calendar number 5-05
505 BZ.
BZ. And this was Carlo finding this one, 59-25 Fresh Meadow Lane. So you don't need to respond to this now because, DOB was, let's say, relied on Victory Van Lines and all of a sudden it's distancing itself from it.
This was a BZ case?
Yes.
This was a
And-
BZ and DOB specifically referred to Victory Van Lines and its applicability to that case. So,
Okay.
it was a
I-
special permit that result, and it was I believe a 7353 special permit that allowed the enlargement of a non-conforming manufacturing building in a residential district. And a neighbor had challenged the legality of the non-conforming use, and that's where the discussion came into play.
Okay, I would like to read it before hypothetically commenting on it.
okay.
But the main thing in Victory Van Lines in comparison to this case is the fact that in Victory Van Lines, there was one CO for the building and that was it. It was never updated to show parking. In this case, the big distinction is the fact that there have been so many subsequent COs. And we will discuss a little bit more about the difference in COs and showing accessory parking versus transient parking. I'll get to that in a second. But
No. So I need to cut you because we can't go on and on with this.
Sure.
We've all read the extensive record. We've read
Okay.
it. We know what your arguments are. I need you to introduce the responses to our questions.
okay.
And with respect to Victory Van Lines doesn't just stand for the proposition that that your C of O has lots of words on it and covers a lot of things. And when it's covering a lot of things, then you have to keep amending your C of O. Victory Van Lines stands for the proposition that if a use is legal and you don't amend the CO to reflect the legal use, it's mere, it's a ministerial, it's just something that was ministerial that could have been corrected as long as the use was legal. And so DOB seems to be distancing itself from that. And we know that the use, as we're discussing, is legal because in 1965, during the special permit, the CO was amended to reflect transient parking. The transient parking, as has been discussed, is not a use. It's the right to use existing parking transiently. And DOB seems to be arguing that you went from one use to another. It didn't become a public parking garage. It simply is a recapture, which is what the MDL waiver is about. It's a recapture provision, just like already exists in the zoning resolution in residential zoning districts. You can recapture as long as you can rent this out to an outsider as long as you allow for a recapture.
So the one distinction that I think hasn't really been discussed that I wanted to make, if I'm low on time, is the fact that accessory parking is not one use or one use group in and of itself. Accessory parking is always accessory to a principal use. So as noted, this building has a long history. It has had transient units, hotel, since its inception. It's also had residential. Accessory parking, accessory to one of those uses, the residential, would be accessory parking under use group 2. Similarly, accessory use to the hotel would be accessory parking under use group 5. They're different uses and you can't just jump from one to the other. In 1965, the variance that was granted by the board to allow it to be used transiently stated or was pursuant to the MDL and zoning provision. I'm forgetting what it was, 36-461, which essentially is saying that if you have accessory parking to the residential use, you can rent it out for short periods of time or long periods of time, but you can rent it out to transients. It doesn't use the word transients, but you are allowed to rent it out to people not living or using the zoning lot. And that's what was granted in 65, but it was accessory parking to use group 2 residential. Now, fast forward to after the variance by no longer being used. It is being used by the hotel as a use group 5 use. That would necessitate a change in C of O. And that is a point that I think wasn't really discussed. Maybe I should have made it clear in the papers. But the fact that after let's say 1980, when the transient parking expired, it is going from a transient parking, which is a subset of use group 2, to a use group 5 pursuant to the building code, which has specific provisions that say when the CO needed to be updated. After 1968, it has to be changed because of the use group change. And that was something that I think was missed.
So your argument seems very technical, and I think that's why Victory Van Lines is something that you should. I'd like that further briefed by you, because what you're arguing is technical irregularity, and that's that's directly cited in Victory Van Lines as not enough to deprive a property right.
Right, and Victory Van Lines specifically referenced a law that came out right afterwards that cannot be applied prospectively, cannot be applied retroactively, which would have been the case in Victory Van Lines, but it could be applied prospectively. That was likely the 1968 building code, which had specific provisions about this. Victory Van Lines in the dicta also said the fact that a reasonable person wouldn't know they had to amend their CO based on the language in the then operative zoning resolution was not enough. It should have been in the administrative code or the charter. And then it referenced that in 1969, something was there that would apply. And it just couldn't apply it retroactively. And that's why in Victory Van Lines, they said they did not have to update their CO because a reasonable person wouldn't have known. But I'm not going to quote the case now, but the general idea is that in after 1968, a reasonable person would know because the administrative code, the building code, was updated to have a specific provision that this would need to be on a CO, because this would be a change of use and use group.
So that means DOB, as of 1968, distanced itself from Victory Van Lines without anyone realizing it, because meanwhile, the board has held so many Victory Van Lines cases, I actually think we could do a search, and all of a sudden DOB is distancing itself because somehow the 68 code changes everything with respect to effectively an allowable use being permitted to continue even though it's not on the CO, even though it's an accessory use, which is permitted as of right, as was the case with Victory Van Lines. So, yeah.
This is
Vice Chair Shanda had a question, and then Commissioner Shabeta, I think.
Yeah, I think my question was that, you know, first of all, when you stated that the 1965 resolution was with regards to accessory parking that were accessory to residential, I think the primary use on this site was hotel, because less than 25% was residential. So the principal use of this facility is use group 6, and multiple dwelling 60 applies to I mean, the multiple dwelling law applies to even hotels, right? Because it's a class B. It's class B. So the multiple dwelling 60 applies to hotel, and it also allows for transient parking space, allows for conversion of accessory parking spaces to transient for multiple dwelling class B, which in this case is hotel. The zoning resolution of 1965, at least I read it a couple of times and I did not see it specifically say conversion of residential uses. It just residential accessory parking spaces. It just said conversion of accessory parking spaces that were in the driveway. And so again, I think that's why I use the MDL as an argument. The MDL 60 allows waivers of accessory, allows transitory use of accessory parking spaces in class B and class A. And in this bill, on this side, there was both class B and class A of multiple dwelling, and the accessory use to be used for parking spaces to be used as transitory was permitted under MDL, and that was the action that BSA had applied for the variance.
And I just want to point out that no C of O in the whole history of this building has ever designated a use group. So we don't actually know whether this is primarily use group 2 or use group 5 or what. And it seems like DOB never forced the property owner to come to a conclusion about it, because it's a 1929 apartment hotel building, and that has a long, complicated history about whether it's an apartment or whether it's a hotel. So they choose not to decide that. So I don't see how you can say that the parking is an accessory to either one or the other, to the hotel aspect, to the residential aspect, to both, because there was no specification on when it's accessory, it's accessory. So if there were accessory spaces under the 1933 waiver, for instance, and the language of accessory use existed in 1916 in the zoning resolution, then whoever's already an occupant of the building is allowed to use an accessory.
So the vice chair pointed out the MDL provision, which is accurate. No matter what the use was accessory to, it would have needed to go get a variance based on that MDL provision. The point is the zoning provision 36461, which hasn't changed since 1961, that provision was only triggered because they were converting parking spaces that were accessory to residence. They would have been able to have accessory parking to the hotel, as at that time, accessory use was permitted for all uses permitted on the zoning lot. This provision wouldn't have been triggered if it wasn't starting as accessory use group 2 residential parking. They wouldn't have, and if you look at the decisions, it cites both the ZR provision, which only applies to accessory parking that starts as residential and is being used for transients, and the MDL provision, which would apply regardless. So if it were at that time accessory to just the hotel, the appeal to BSA for a variance would only cite the MDL provision. It would not have cited the zoning provision. That's what leads us to believe that it was accessory use to residential at that time.
I think this is, again, it's like doing the belts and suspenders. At that time, probably the parking spaces were not separated out for residential. They were all used together for residential and for hotel uses. And this was to ensure that if there was any confusion that would be there in future, you apply it on both of them if in case one is being used by residential residents. So you're covering your grounds. It's like belts and suspenders, covering your grounds with regards to residential accessory parking and also commercial parking spaces. But that doesn't mean that all of the 22 or 27 parking spaces were all for residential purposes or so. Again, but that's like a minor technical issue. What we are still not convinced, I think what you've heard from the testimony, none of us are convinced that there was at any point during this long history of the COs that at any point the existence of accessory parking was ever lost. It was always there from the 1933 point onwards, and based on the understanding that there was accessory parking permitted, the regulations kept applying over it. If any of the other commissioners want to weigh in, please do. I see Madam Chair is silent.
Okay. The quick succinct point to that, response to that is, and these have both been said, is that the department views that there are different uses, use group 2 and use group 5. And so to the extent that it was permitted to have use group 2, and that's what authorized the 1965 variance, then when the variance expires, the variance that was permitting transient parking, which is some sort of non-as of right subset of use group 2, and it was converted to use group 5, that would necessitate a change of CO based on 27-217 B, A and B in the building code, because that would have been a change of use and use group. That's the general idea, and that the fact that the CO said transient parking when it was being used as accessory to the hotel are two different uses that would need to be changed. That's the general idea.
I see Commissioner Otley Brown has raised her hand.
Yeah, it just seems to me that if it was never specified in the first place, we can't then take today's way of interpreting things and apply it back 100 years. It doesn't make sense to me. It wasn't specified in 1933. You're only assuming that it had to do with use group 5. You're then making an assumption that in order for transient parking to be put into effect, it had to then switch to use group 2. These are assumptions. I think it was probably not specified back then, because in 1933, very few people had cars. It almost probably was not specified because it wasn't, who even knew that it was ever going to be an issue at that time. So I think that you're taking that and using the fact that it wasn't specified to hold it against them based on assumptions you're making here in 2020. That couldn't possibly have been a fact back in 1933, when probably only the wealthiest people had cars and not even all of them did.
So I don't think it's so much assumptions. We're trying to work with the evidence that we have on a case with a long history. The 1933 appeal specified that it was for what the use was going to be for, and at that point it was for serving the hotel. And in the zoning provision 36-461, which hasn't changed, so the interpretation is based on what was there. It didn't need to be used. It didn't need to be triggered if you were going to make it accessory to the hotel. It was a change in use because the hotel at that point did not need accessory parking. It was being used and rented out to transients. And we're trying to make a picture based on all of the hundreds of pages that were submitted. And the pages show that in 1965, the original use, which would have been accessory to the hotel, was no longer needed. And so it made sense that at that point, they had the driveway. They can get extra money by renting it to people in the street. They didn't need to get a variance under zoning if they would have kept it as accessory to the hotel. They would have needed a variance under MDL no matter what. And the fact that they were using it for the fact that they did get a variance from zoning, that's what we are basing the fact that they had residential parking, and the switch in use group is what triggers the new CO. So there has been some form of parking.
Mr. Sultan, I really am very confused. I'm looking at the resolution of 561-65BZ, and the subject says, decision of this borough superintendent under section 63 of the multiple dwelling law to permit in a C53 and a C6 district in an existing multiple dwelling the addition of transient parking for the unused parking spaces for a temporary term of 15 years. Now, the term multiple dwelling is being used because
That's what the building was.
the
Right,
building
no,
was, right, a class B, it had class B and class A multiple dwellings. So it's using multiple dwelling terms. So I'm just confused. And now as I reread this resolution, which is very brief, there's no reference to residential. It just keeps saying section 61B of multiple dwelling law. There is no reference to any of the other zoning resolution section.
Sure. If you keep reading, it does. Right after it says the resolution, it says, whereas a public hearing was held on this application on September 14th, 1965, after due notice by publication in the bulletin, and this is where it references it, where the decision of the borough superintendent dated April 22nd, 1965, acting on alteration application 530 of 1965 reads, proposed transient parking in a multiple dwelling, that's just referencing the building, which is located party in a C53 and C66 zoning district, is not permitted as per section 36,461 of the zoning resolution.
Right, that's because it did not allow commercial accessory uses to be, I don't think the regulation, and this is where I would like a little bit more clarification, is I don't think the zoning resolution at that time allowed commercial accessory parking spaces to be used for transient under the zoning regulation, though the multiple dwelling law 60 allowed, but the zoning resolution hadn't caught up with the multiple dwelling law, which it did later on. So that is why section 36 is there. 36 applies to commercial districts and commercial use. If it was a residential purposes, if it was for residential purposes, then the residential zoning regulations, I think would have been, what I'm getting at is that the zoning resolution was not at that time current with the MDL 60. And that is why it sought a variance under MDL 60. So I think we're going around on this, and we would like more clarification as
Definitely.
to on these matters. Are there any other questions from any of the commissioners? Commissioner Shabeta.
Council, I have it certainly feels to me, and I'm sure that some other board members may feel the same way, that you're basing this denial on assumptions, and I think you need more than that to deny a property right.
Understood. Are there any specific assumptions any specific things that seem like assumptions that I can try to address?
I think we've been going through them. I think that.
Okay, I will try to clarify more as to law and case law citations as opposed to anything that can be construed as guesswork.
I appreciate that, Council.
Yeah, thank you. Mr. Selver, do you have anything to add?
I'm thinking, I guess I wanted to make a couple of points based on what Mr. Zoltan had to say. Number one, although we have cited Victory Van Lines quite frequently, we've done a little bit in thinking about this a little bit more. I think we feel this is not a non-conforming use. This is a use that is permitted in the zoning district. It's just permitted subject to a different set of conditions in existing buildings than it is in new buildings. So it's we're really dealing with a conforming use, and therefore Victory Van Lines does not strictly apply. Now, we believe that even if Victory Van Lines did apply, we would still have established the requirements for maintaining the use of public parking, of accessory parking after 1980. But we don't think it applies, and we think that the continuation of the accessory parking use through 1982 is sufficient to give us standing to continue continue to be subject to those rules, the pre-1982 rules for the current accessory parking that was there before the renovation started. And number two, on the 2010 CO, just, we actually looked back to see what happened to the driveway reference on the 2010 CO, which we don't feel, the absence of that, we don't feel is a significant in any event because of the notes at the end of it. But what happened, interestingly enough, is on the statement A, Department of Buildings, the proposed use was listed as no change from the existing use. And as we all know, the prior C of O had listed the driveway and the transient parking. The existing use, for whatever reason, omitted the reference to the driveway, which we think is probably a Scrivener's error. And we hope that the board and the buildings department also will not consider that Scrivener's error to be dispositive and critical in this exercise. We will also obviously speak to the issues as to the zoning in our follow-up submission. We'll speak to the issues of the history of both the zoning and the building code changes from the 1932 on. And we have some other comments on the continuity of accessory use of the parking, really beginning in 1933 and continuing under one term or another through the current day.
I think what I am hearing from all the commissioners is that thus far, we are not convinced by DOB's arguments that has been presented so far. And we have asked for additional information more for just to clarify and other things, but can I get an idea of whether the commissioners want to close and have the applicants submit all the documents more for clarity? I'm seeing a nod from Commissioner Shibata, Commissioner Otley Brown. So what I think I would suggest that, Council, okay, I'm getting a thumbs up from Council also. Okay. So in that case, I would suggest that we close and have all additional documents to be submitted that clarifies your position. But I don't, and should anything that you submit change our review, we will reopen and rediscuss it. But thus far, we are not convinced by any of the evidence that's been provided by DOB.
Madam Vice Chair?
Yes?
May I suggest that before, if the board goes to a vote, we just check to see if there are any members of the public that wish to speak?
Absolutely. Thank you for that reminder, our Executive Director, Mr. Constanza.
Okay, the case that we're discussing right now is 2020 11A, 301 Park Avenue, Manhattan. This is an interpretive appeal filed by Kramer Levin.
And while
You're
we're
currently asking for the members of the public if they'd like to speak.
Right.
While we're waiting for members of the public to call in, how long do you expect that it would take to submit?
From our perspective, I would say we'd like 2 weeks, 3 weeks should be more than enough, but 2 weeks, we would like, because we'd like to move this quickly, we would say 2 weeks and we would get our papers in.
Okay, and would you like to reply to DOB's submission?
We want to have DOB first.
We certainly wouldn't want to give up that right. So the answer is, I'd like to have the option. You can give us a very short window in order to do that, though.
Okay, or would would having DOB submit first make more sense administratively to move this along?
It might be because most of the questions were addressed to DOB.
Yeah.
So why don't we do it that way? And then I think I would want 2 weeks or 3 weeks to respond. So
Okay, and DOB, would you like about 2 or 3 weeks as well?
If I could have 3 weeks, but to the extent that there may be a new argument that this may be a conforming use and not a non-conforming use, I would ask a chance to respond to their papers as well afterwards, a SIR reply.
well, I think we've made we've made the point. I don't think we're going to go into any much more detail. I think the zoning is pretty clear on this. Essentially, if you feel it is not a conforming use, then I think you can certainly take issue with what we've said. But the basis of our saying that it's conforming use is that you can, in fact, establish parking, accessory parking on an as of right basis in new buildings. You can get the right to accessory parking in existing buildings pursuant to an authorization, which is in the nature of a special permit, which the courts have held to be a conforming use. And you have the right to continue the accessory parking that you had prior to 1982, subject to the rules that were in effect prior to 1982. So I would say that in that sense, even if nothing else is a conforming use, our parking would constitute a conforming use. So that's, Michael, that's kind of what our position is. I guess if you want to respond to that specific argument in a SIR reply, I'm not going to object.
Okay. Just to the extent there are new arguments presented in papers, I would like the opportunity to respond to those arguments in kind. That is all.
Understood. So we will be in touch with the briefing schedule, and we'll set it for a decision at a later date as well. Vice Chair Chanda, did you want to make a motion?
Yeah, I would like to make I would like to make a motion to close.
Chair Chanda, Vice Chair Chanda? Oh, I'm sorry.
Sorry. Yeah.
You
Yes.
okay?
Yeah. Yeah.
Okay. Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Wait,
Commissioner Shabeta?
I'm sorry, aye.
Okay.
Aye.
Commissioner Sheta, can you repeat that? I'm sorry.
Yes, I apologize, I was muted, aye.
Okay. Okay, fine. This application is closed.
And we will be in touch. Thank you.
Okay,
Thank
Thank
you.
you. Take care.
Thank you.
thank you, everyone.
thank you. There was no members of the public that called in.
Right. So should we revert back to the original
Yes.
lineup and
So the next case would be 2017-99A 3798 Railroad Avenue, Queens. Once again, this is a public hearing for July 14, 10 a.m. Faye and Baton is the applicant. Somebody mute. There's too much background noise. Thank you. All right, I just emailed her. Is she in? Oh. Let's see if she's in.
She is joining and connecting to audio now.
Okay. Thank you, Kurt. I didn't see it.
Please state your name when you can hear us.
Oh, okay. Can you hear me?
Yeah.
It was delayed. Okay. Fayan Batan from Sheldon Lobel PC for the applicant. We attended this morning's review session. I know that there were minor comments. One of the concerns was regarding the tax lot issue, because there were lots 279 and 280 that we had referred to in our cover letter that was outstanding at the time that we made the submission. Basically, just a quick history, when we originally applied for this application, it was lots 279, which was for a fabric enclosure. Then the C of O application at DOB was filed under lot 280. The two tax lots merged into lot 279. It just wasn't reflected on DOB on BIS. But recently, if you actually, I believe the expediter told us that it was fixed. And if you go to the original job number in which we got the DOB denial, which was under job number 421664443, that's now in term with lot 279. It used to be lot 280. So we believe that has been corrected. It shows lot 279 as obsolete, but if you actually go into lot 280, click on that job number, it comes up as lot 279. So that was the outstanding issue with DOB and the tax lots.
Thank you for clarifying that.
And I think one of the original comments regarding the occupancy, the parking of cars, FDNY originally stated that they were fine with a condition in the resolution. That was their original statement. I just confirmed it with Mr. Daly. I don't know if he's on. I can't see. You want to check with the fire department with DCI Daly.
Yeah.
Good morning, members. The fire department would like the condition to be noted on the resolutions. This way I can upload the resolution to the fire department files for access by fire prevention and fire operation. And it's easier for us. The fire department is now, wants these the resolutions and plans to be uploaded to our files for their records. So we would prefer we want the resolution to list the two conditions. Thank you.
So I think the commission was thinking of doing both, not only adding the note to the resolution,
Restrictive deck.
but also issue a restrictive deck.
Well, it's my opinion. I think I would just want the resolution for the fire department use. For the restricted deck, we have no use for that, nor would we be searching for it for any reason.
Okay.
The resolution is the only thing that will be uploaded to our files. That's
okay.
The file they'll permit me to do.
Thank you for clarifying.
I'm sorry?
Thank you.
Okay.
Are the commissioners, do you have any other questions? Do we want a restrictive deck? Yes. I'm seeing.
I'm okay with either restrictive deck or condition. I leave it, like I said during the executive session, I leave it to the fire department. If they prefer restrictive deck, I would go with it. If it doesn't make difference, I would say condition is.
I believe the fire department is well aware of this case and they do visit the site often, or they have before. I know there's a relationship between the applicant and the businesses along Railroad Avenue and the fire department. So if the fire department's just okay with the condition, they know about the site. It's active. So, I mean, we would obviously prefer to put this just in a resolution as a condition.
So yes, Mr. Daly.
I'm sorry. I wanted to add, because of the accounts that we created at this establishment, we will be doing annual inspection. So when the inspector does visit the site, they'll be taking the resolution with them. So that's how it's easier for us with the resolution.
Okay.
That helps in determining how you want to do it.
Okay.
Thank you.
Okay. Any other questions from the commissioners? Okay. You know, given that this is going to be more of the concern that we wanted to be recorded in the restrictive deck was more of a fire department concern. And if fire department is completely satisfied with it being on the resolution, and as Chief Daly mentioned, that this would be monitored on an annual basis, it is a responsibility of fire department to ensure that the site is complying with all the conditions that would be laid out. And should there be any divergence from that, then I'm sure Chief Daly will not hesitate to bring it to our attention. So with that, if it's okay, I will forego the restrictive deck since the fire department is going to be very much wanting to monitor this on a regular basis. We have that assurance. So is that okay with the rest of the commissioners? Okay. In that case, if there aren't any, yeah,
Public.
thank you. Are there any members from the public that would wish to speak?
2017-99 BZ 3798, I'm sorry, Railroad Avenue, Queens.
In the meantime, I could just share with council, if we close today, I could just share with council the updated biz printouts to make that easier.
Thank you.
Okay.
So I think we're good.
I think we're good. So no one has signed up. So I make a motion to close.
Okay. Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Okay, so this application is closed and we don't need anything else, right?
Right. No new
Submission?
submission needs to be, other than the note from the biz that will be forwarded to our general counsel with regards to the tax lot. And so I think we will set a date for decision later on.
Yes.
Yes.
Okay.
Thank
We
you.
will have conditions when we do go through, then we will read those conditions at the date, on the date of the decision.
Understood. Thank you.
Thank you.
Okay. Next application is 2019-19A 107 Monet Avenue, Staten Island. Applicant is Rothkrug, Todd Dale. This is a public hearing.
Has anybody signed in?
Yes, he is connecting to audio.
Okay.
Please state your name when you can hear us.
Good afternoon, Todd Dale for the applicant, or maybe it's still morning, or it's noon. So
It's afternoon.
good noon. I don't need to be sworn in for an appeal, correct?
No.
Okay. So from review session, we did listen to the review session. In response to a commissioner, I believe Commissioner Shabeta raised about the community board, can provide a little bit of clarification as to their report. Just to confirm for the board, we did provide everything that was in the record to the community board. Their comments with respect to their recommendation they submitted were in reference to materials that additional materials with respect to the application that they believed weren't provided. However, with respect to those materials, we informed them either that yes, they were provided or that it was premature. The items that they asked about, just to go point by point, the first is they asked for a diagram showing where the CCO ends on Manee. At the actual land use committee meeting, We provided to them the topographical map, which was part of the initial submission, showing them where it ended. We also provided a survey. So they just didn't believe that that's where Manny was. So I can't speak to their lack of acceptance of the topographical map that was provided. They also asked about a deed restriction, respect the declaration. We informed them at the time that a restrictive declaration would be provided for the board to review. However, it was premature to provide any restrictive declaration because that was predicated on an acceptance of the board of the site plan. And so at that time, we didn't have it to provide because it normally happens later in the process. But as the board knows, we had provided the draft restrictive declaration to the board. And then with respect to the last item, the fire department letter, we let them know that it would be submitted as part of our next response and forwarded to the community board. At the time that this meeting was held in February, the notice of comments had not yet been issued, so we didn't have the submission with the fire department letter. That department letter is now, though, part of the record, or excuse me, the map is now part of the record. And I would also note that in February, when we appeared before them, that we gave them the option of adjourning this to a later meeting if they wanted to see that fire department, but they chose to go ahead and go forward with the vote anyway. So I would just point out that from a required standpoint, as far as the board rules require the legal requirement, the full application was provided to the community board, and that their comments in their recommendation are not for any of the materials that were record. They were extra materials, and we tried to provide clarification of that, but they chose to proceed with the vote anyway. So I don't know if that answers the question, or if there's any other questions about that I can answer at this time.
Shampa, you're muted.
Commissioner Shabeta?
You're muted, Commissioner.
Sorry, just going through my notes. Has anyone reached out to the community board? It'd be great if someone reach out to the community board and see if there's any other issues that they have.
All right.
Thank you.
So, so I think the only outstanding is making sure that the community board has received all the necessary information, including the latest FDNY letter, which, as Mr. Dale stated, that it was provided, but not in time for their vote. And maybe at this time, and this is a question for our council, can the draft restrictive deck also be shared with the community board? Or do we share it with the community board?
Because it's been submitted to the record, it can be.
Okay.
If I could just speak to this, the community board has issued its final recommendation. So from a legal perspective, this has already been provided. The community board has issued a vote, and this satisfies all the board's rules and requirements. The only reason I mention this is that, as the board would be aware, most community boards within the city now are closed due to the current public health situation. I believe that this is community board 3. I know they're not conducting any public hearings, and I also believe they're on summer recess. So, I would just say, we did everything we could to respond to community board questions, and I'm not trying to ignore community board questions, but because of the current circumstances and because of the timing of this application and the fact that it's summer recess, I believe it would be punitive to delay this application any further for a property owner, for a community board response when they voted, when they had the option to delay back in, early in the year, but to delay any further until the fall for this property owner.
Council, I believe that I believe your representations. I don't believe it's going to be punitive towards a property owner because we don't close and vote right now anyway. We'd have to close and put it on for a later date for a decision. In the interim, all I ask is that the case manager reach out to the community board, see if everything's in order, and at that point, I don't think it's going. While I'm not responsible for the scheduling of the matters, I'm not sure that this will be something that's going to create a hesitation. And I do believe that the community board, I believe that when I read a report from a community board saying that they haven't received the full packet, I'm curious to find out what the circumstances are from their point of view.
Understood. We understand, and if the case manager reaches out, we're happy to provide extra information. I'll reach out to the community board again after this hearing just to say that this issue came up and to clarify any questions they might have about the vote. Our concern, though, is since this did have a final recommendation issued by the community board, we would object to any situation where this is held up for the community board to reopen this and rehear this and reissue another recommendation when it's been satisfied and we satisfied all board requirements. I also don't believe that based on what I've heard from discussion during review session and prior hearings, that the substantive issues have largely been satisfied with respect to the commissioners, and it's unsure what community board input would do to change the commissioner's position on this case. So I understand, and we'll continue. And if we can reach out, we can send this information again. We're just in light of current circumstances, hesitant to have this drag on and on.
I would add to this is that you're right that the community board has been given the chance to vote, and they have voted, and you had provided whatever information that was on record at that time. It does not, we can close and vote at a later time, but in the meantime, we can reach out to the community board. You can reach out, and our case manager can also reach out to make sure that they have received all the subsequent documents, which is the FDNY letter and the restrictive debt. And if those were the concerns, that's fine. I don't think we need to then respond, get a vote. I wouldn't want to hold off our decision based on the community board's vote. If their concern was they did not have those documents have been provided. And as I think what we have been discussing, our concerns here have been addressed. So I'm okay with that direction. Is that okay with everybody?
That's fine by me.
Okay.
All right, I'll reach out to the community board.
Yes, please do. And in the meantime, Mr. Dale, if you can just, for our record, just provide what was submitted to the community board initially.
I would just say right now, initially, this first meeting was held February 13th. And
Okay.
that was after the initial applications. The only materials that were provided to the community board at the time of the hearing were the initial application materials. Subsequently, when we responded to the notice of comments or other submissions, those get sent to the community board, but it was after the community board had already voted. So it's unsure if those were ever reviewed by a committee because the committee would consider it closed. But I would just say that this afternoon, I will reach out to the community board. I know the district manager. I will copy Ms. Matias on the message. I will send a follow-up message and attach all of the documents that are referenced in this recommendation, the fire department letter, the draft restrictive declaration that exists now, and the CCO, or excuse me, the topo map, and ask them if they have any additional questions and explain the current situation.
Okay, thank you. I think if their concern was also the deed, you couldn't have provided even after the notice of comment period, because that comes out of the BSA hearing process.
Understood.
So is there anybody from public that would want to speak on this matter?
This is 2019-19A 107 Monet Avenue, Staten Island. Good.
Is there anyone? Did I hear anybody?
Nobody has called in yet.
Nobody has called in? Okay.
No.
Okay.
Okay, so in that case, we can close, and meantime, both Mr. Dale and our case manager will reach out to the community board to make sure they have received all the subsequent documents.
see if they have any questions or,
and see if they have any questions. Yeah.
okay,
And if there are questions that are relevant, we'll open and hear it then.
okay. Madam Vice Chair,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Okay.
Okay.
Concludes the public hearing for July 14th. The 10 a.m. session will resume at 2 p.m. for the afternoon session, review session and public hearing.
Okay.
Okay, thank you.
Thank you. Thank you all very much.
Thank you.